Senator Spector's at the head of the dais there. The witnesses for the American Bar Association are lining up, and this is about to get underway.
The Judiciary Committee will now proceed with the confirmation hearing on Judge Samuel Alito for the Supreme Court of the United States. After our morning session, the committee met in executive session and reviewed confidential data on the background of Judge Alito, and it was all found to be in order. We're now proceeding with the witnesses, the tradition of the outside witnesses, the independent witnesses. The tradition is to hear first from the American Bar Association and their evaluation of the judicial nominee. We have structured this portion of our hearing differently from what had been done prior to last year, and that is where the majority took most of the outside witnesses. The tradition has been to have 30 witnesses, and the majority party had taken 18 and the minority party 12, and it seemed that it would be more appropriate to have an even split 15 and 15, and that is the practice we are following. And of course the ABA representatives are not witnesses called by either Democrats or Republicans, and we have really done our best to proceed in a not non-political way in the selection of a Supreme Court justice. There can be different evaluations as to how successful we are in that, but that has been our effort. We have a limited testimony to 5 minutes for outside witnesses. The next witness already nods in agreement. He was here not too long ago for Chief Justice Roberts, and we have established the 5-minute rule because we have 31 witnesses, and the Senate is not in session, and all the members of the committee have other commitments, and it is projected that we will finish today, but we'll have to keep on schedule. We turn now to the American Bar Association panel, and we welcome Mr. Steve Tober, Ms. Marna Tucker, and Mr. John Payton. In accordance with the practice, the testimony will be given by Mr. Tober, who is the chairman of the American Bar Association Standing Committee on the Federal Judiciary. He's an attorney with a law firm bearing his name, experienced in civil litigation, professional negligence, and domestic relations, undergraduate in law degree from Syracuse University, on the board of the Law Review, deeply involved in New Hampshire and New England legal communities, former chairman of the committee to redraft New Hampshire's rule on professional conduct. We know the laborious job involved, Mr. Tober, which you are about to describe, in reaching an evaluation of a Supreme Court nominee and the importance of your judgment. So we thank you and Mr. Payton and Ms. Tucker for your public service. Now, Mr. Tober, the floor is yours.
Thank you, Your Honor. Thank you, Mr. Chairman, members of the committee. My name is Stephen L. Tober of Portsmouth, New Hampshire, and it is my privilege to chair the American Bar Association Standing Committee on Federal Judiciary. I am indeed joined today by Marna Tucker, our D.C. Circuit Representative, and by John Payton, our Federal Circuit representative. For well over 50 years, the ABA Standing Committee has provided a unique and comprehensive examination of the professional qualifications of candidates for the federal bench. It is composed of 15 distinguished lawyers who represent every judicial circuit in the United States and who annually volunteer hundreds of hours of public service. Our committee conducts a thorough, nonpartisan, non-ideological peer review using well-established standards that measure a nominee's integrity, professional competence, and judicial temperament. With respect to a nomination to the United States Supreme Court, the Standing Committee's investigation is based upon the premise that such a nominee must possess exceptional professional qualifications. The significance, range, and complexity of issues that will be confronted on that court demands no less. As such, our investigation of a Supreme Court nominee is more extensive and is procedurally different from others in two principal ways. First, all circuit members on the Standing Committee reach out to a wide range of individuals within their respective circuits who are most likely to have information regarding the nominee's professional qualifications. And second, reading groups of scholars and distinguished practitioners are formed to review the nominee's legal writings and advise the Standing Committee. The reading groups assist in evaluating the nominee's analytical skills, knowledge of the law, application of the facts to the law, and the ability to communicate effectively. In the case of Judge Alito, circuit members combined to contact well over 2,000 individuals throughout this nation. Those contacts cut across virtually every demographic consideration, and it included judges, lawyers, and members of the general community. Thereafter, circuit members interviewed more than 300 people who knew, had worked with, or had substantial knowledge of the nominee. All interviews regarding the nominee were fully confidential to assure the most candid of assessments. Judge Alito has created a substantial written record over his years of public service. Our three reading groups worked collaboratively to read and evaluate nearly 350 of his published opinions, several dozen of his unpublished opinions, a number of his Supreme Court oral argument transcripts and corresponding briefs, and other articles and legal memos. The academic reading groups were composed of distinguished faculty from the Syracuse University College of Law and from the Georgetown University Law Center. The practitioners group was composed of nationally recognized lawyers intimately familiar with demands of appellate practice at the highest level. Finally, as we do in any Standing Committee investigation, a personal interview was conducted with this nominee. Judge Alito met with the three of us on December 12th, and he provided us a full opportunity to review matters with him in detail. After the comprehensive investigation was completed, the findings were assembled into a detailed, confidential report. Each member of the Standing Committee reviewed that final report thoroughly and individually evaluated that nominee using three rating categories: well qualified, qualified, and not qualified. Needless to say, to merit an evaluation of well qualified, the nominee must possess professional qualifications and achievements of the highest standing. During our investigation, questions were raised concerning the nominee's recusal practice and also concerning some aspects of his judicial temperament. We have carefully reviewed and resolved those questions to our satisfaction, as we have detailed in our accompanying correspondence to your committee, which, Mr. Chairman, we ask to be made part of this record.
Without objection, they will be made part of the record.
Thank you, sir. We are ultimately persuaded that Judge Alito has, throughout his 15 years on the federal bench, established a record of both proper judicial conduct and even-handed application in seeking to do what is fundamentally fair. As such, on the basis of its comprehensive investigation, and with one recusal, the Standing Committee unanimously concluded that Judge Samuel A. Alito, Jr. is well qualified to serve as Associate Justice on the United States Supreme Court. His integrity, his professional competence, and his judicial temperament are indeed found to be of the highest standing. Mr. Chairman, let me say once again what we noted here back in September. The goal of the ABA Standing Committee has always been and remains, in concert with the goal of your committee, to assure a qualified and independent judiciary for the American people. And with that, thank you for the opportunity to present these remarks.
Thank you very much, Mr. Tober, for your work and for ending right on the button, 5 minutes to a T.
I worked on that, Mr. Chairman.
Before, that quality of yours would recommend you for Supreme Court argument where Chief Justice Rehnquist stopped the speaker in mid-sentence. And the word from Judge Becker, who will testify later, he was looking for an opportunity. He stopped me in mid-sentence one day, and he's looking for an opportunity to stop the speaker in the middle of the word if. I didn't give him that chance. Before proceeding to questions, I want to yield to Senator Leahy to see if he has any opening comments that he wants to make.
I don't, Mr. Chairman. I don't. Thank you, though.
We have 5-minute rounds for each of the members of the committee. Mr. Tober, picking up on your testimony that you found Judge Alito to have even-handed application of the law, how would you amplify that with respect to what kind of materials you looked at, what your evaluation was, and what led you to that conclusion?
I'd be happy to, Mr. Chairman. The conclusion was reached in large measure in interviews with, as I said, well over 300 individuals around this country, over 130 of whom were federal judges. Many were state judges. Many were colleagues, co-counsel, opposing counsel, who almost uniformly talked in terms of his even-handedness, of his open-mindedness, of his willingness to be fair. He's called a judge's judge more than once in those interviews. When we interviewed him, we had questions that would have been on that issue, and we discussed that issue with him to get his own personal perspective on it, and we were satisfied with what we heard at that time. And perhaps it's best reflected in his writings, which, again, I indicated the body of that work was read by our 3 reading groups collaboratively. And the conclusion that was reached, if you will, the overarching conclusion that was reached, is that this is a judge who brings pragmatic skills to his decision-making. We discussed that with him in that interview that we had on December 12th. He tries to do what he thinks is right with respect to the application of the law that's before him. He took us through how he analyzes that approach, up to the point that when he is just about ready to release his decision, he looks back once again at the law to make sure he hasn't misapprehended something in the first instance, and secondly, to make sure that the outcome is fair. That, to me, suggests...
So he came back to you twice?
I'm sorry?
Was your testimony that he came back to you? What did you mean when he came back and took another look?
He would look at his draft opinion, Mr. Chairman, before it would be issued. And he would look back at the law that he was applying in that opinion and the outcome that was occurring in that opinion, just to justify in his mind one more time that the outcome would be fair.
Did your group study all of his opinions?
The reading groups read 350 of his published opinions, scores of his unpublished opinions, and other materials, yes.
And did they make any analysis? An issue has been raised as to whether Judge Alito unduly favored the powerful or the government. Did your ABA analysis reach that issue?
That issue was one that we looked at, and we discussed it in our letter of evaluation. And I gave some examples of some of the disparate results that we were told about. One of the reading groups reported to us that they could not reach a full conclusion on whether or not there was some attempt to favor one outcome for a group of litigants over another. And while there were a couple of members in a couple other reading groups that may have said the same thing in so many words, there were a significant number of other individuals in the reading groups who said they couldn't find any such evidence of that. It was inconclusive with respect to the reading groups. What was of interest in the reading group reports to us was a comment that was echoed by others, which is that in looking for a sense of partiality in the opinions, the conclusion that was left very often was one of pragmatism.
Let me interrupt you because my time is almost up to ask you to clarify what was inconclusive in your studies.
It was inconclusive whether or not there were certain categories of parties who might have come out at the wrong end of Judge Alito's opinions.
Did some of those readers find that he was impartial and some find the contrary?
My understanding is it was inconclusive. We did not receive any clarion call at one point that he was representing or suggesting to have a bias against any particular group of litigants before him.
A considerable amount of attention has been paid in these hearings to the recusal issue of Vanguard. Would you comment on what your committee found there?
I'm going to defer to Mr. Payton, who took the lead on the Vanguard-related issues, if that's okay with the chairman.
Mr. Payton?
We certainly looked into all of the recusal issues. We asked Judge Alito in some detail about how the Vanguard and the other recusal issues came about. But let me put this in some context, which I think will be helpful. In the materials that Judge Alito submitted to this committee, he attached a list of all of the cases from which he had been recused over his 15-year tenure. And that is 40 pages long with about 30 to 35 cases per page. It's well over 1,000 cases from which he was recused. Among those cases that he was recused from were cases involving Vanguard in 1992, cases involving his sister's law firm throughout the tenure, cases involving the U.S. Attorney's Office throughout the tenure, cases involving the other entities that he had identified in his representation to this committee back in 1990. A few cases, in fact, slipped through, and that has been the subject of our inquiries and some of the testimony before this committee. We asked him how that came about. He explained how he thought it came about, but I think it's fair to say he was not certain how they slipped through, whether it was through the screen, whether it was because they were pro se cases. In the end, he did acknowledge that it was his responsibility, that a mistake, an error had been made. Those cases should have been caught, and he should have not heard those cases. We listened quite carefully to all of that, and in the context in which we understood how this came about, we accepted his explanation that he simply had made a mistake. These cases should not have slipped through the screen, just like the other 1,000 or so cases were captured by the screen in the process, but they did. They shouldn't have. We think that did not reflect in any significant degree on his integrity. Let me tell you something else we did that goes to both of your questions, Mr. Chairman. We also interviewed an incredibly broad array of judges, virtually all of the members of the Third Circuit, virtually all of the district judges that were in New Jersey and were in Philadelphia. We interviewed a number of the other judges in the Third Circuit who were on the district court who had contact with Judge Alito. What we learned from them almost unanimously was that he is held in incredibly high regard with respect to the issues that this committee, the ABA's committee, looks at: his integrity, his judicial competence, and his judicial temperament. And on the issue of the recusals, everyone thought that he has the highest integrity, and that these few cases that slip through do not diminish his integrity.
Thank you, Mr. Payton. The red light went on during the course of your testimony, so I will terminate and yield to my colleague, Senator Leahy.
Just to follow up on that, on Vanguard, the only reason I even mentioned this, when the initial explanations was from Judge Alito in the White House after his nomination, was a computer glitch had precipitated Vanguard case. But then he answered some questions from Senator Feingold. I said in the Monga case, it wasn't a computer glitch. On his failure to submit Vanguard to the clerk of the court. Then he said when it came before him, he was not focused. Since your report is filed, we've learned that, I was checking the dates here, we've learned that Judge Alito did not have Vanguard on his recusal list far back as 1993. Notwithstanding the fact that in 1990 he had given a sworn statement to the committee that he would recuse. As some of that information came after your report, would it change anything in the conclusion?
I think that it's, like I said, from the interview with him, I'm not sure we figured out what caused these cases to slip through. I'm not sure Judge Alito knew the precise answer to that. But he did acknowledge that it was a mistake. On what was on his standing and recusal list, I don't know what was on his standing and recusal list, but I just note in the materials that were submitted to this committee, there is a 1992 entry of an entity that has the name Vanguard in it, it's Vanguard, that says recusal because on standing recusal list. I don't know what happened in 1993. I don't know if things went on and went off. Something went wrong here, and these cases came before him, and they shouldn't have, but they are a very small number in a huge universe of cases from which he was recused.
Senator, may I add to that very briefly? Sure. We did not find in the vast number of our interviews and the review with the nominee and any other extrinsic information we could look at, any pattern of intentional effort to try and have Judge Alito impose himself in cases in which he did not belong. We are persuaded that some errors were made, some mistakes were made, and they total up to a small handful. In the course of the numbers that he's been sitting on, and I believe Senator Hatch suggested yesterday some 4,000 or 5,000 cases have been adjudicated involving Judge Alito. We took that into context, particularly in light of the comments from individuals who know him and work with him with respect to the ethics he brings to the position.
You understand the reason it became an issue here is because it was based on a sworn statement.
Yes.
They'd recuse. You also looked into his open-mindedness, his commitment to equal justice. I'm just asking, in doing that, because I've never served on one of these committees that you're on, there's been a number of studies of the judge's record, Knight Ritter, the Washington Post, Cass Sunstein, and others, and they've concluded he had a much more likelihood of siding against discrimination plaintiffs than other circuit judges. Knight Ritter reviewed 311 of his published opinions, found that he seldom sided with a criminal defendant, a foreign national facing deportation, employee alleging discrimination, or consumer suing big business. And his record stood out significantly from others in the circuit. Did this question come in on the issue of whether he was compassionate or?
The answer is yes. We looked at that. Our reading groups looked at it for us. We discussed it with the nominee in our interview on December 12th. We are not immune from the media stories that have been available. I suggest everybody on my committee has been watching the last 3 days very carefully. We are where we started with that issue, and that is the over 300 people we spoke with who know this person as a judge, as an individual, are convinced that he has an open mind, that he does not bring any bias to his decision-making.
And lastly, on the issue of Cap, nobody is suggesting a bias on his part, but what bothers me while you're doing a job application in 1985, I know Judge Alito is a very careful person, and I mean that as a compliment, and a carefully put together job application. He proudly proclaims his membership in CAP, a group that was very much dedicated to keeping minorities and women out of Princeton. One that would probably look unkindly toward either Judge Alito's Italian ancestors or my Italian ancestors. Why did this? Was this just pandering to the Mies and the Reagan administration, or is this just a total screw-up?
May I defer to Ms. Tucker with that?
Sure.
We looked at that question, Senator. We were very concerned about that listing, knowing that membership in that organization would put him perhaps on an extreme that we would be uncomfortable with. His answers to our committee were very similar, if not identical, to the answers to your committee. He did not recall when he became a member or even what he did, but he didn't recall ever attending any meetings or reading any publications. He did recall that he joined the organization because of the university's attempt to remove
But that's not really
ROTC.
my question. Was there any question why was he so proud of this that he would put it in 1985 when everybody knew what kind of an organization it was, where Senator Bill Frist had condemned it, and Senator Bill Bradley had going, the extreme political polls, I suppose you might go. Did you ask why he proudly put that on his?
We asked him why he put that on there. We didn't ask him why he proudly put that on there. But he stated that he recalled he was a member. We specifically asked him if this was since it was a job application, that was he pandering? And he said it would be improper to not tell the truth on an application, that he was a member of that organization. But there were only 2 organizations that he listed, as I recall, on that application. One was the Federalist Society, the other was the Concerned Alumni for Princeton. He did not have a long list of activities at that time. But I should say, in fairness, we were very concerned about the membership of that and what happened. And all of the people we spoke to on the courts, women and minorities, people who he had worked with, people who had sat on panels with him side by side in issuing judicial opinions, almost universally said that they saw no bigotry, no prejudice. They thought he was a fair man. And they felt that if he did put that, they were shocked when they heard that that was listed on his application. And they said, that is not the Sam Alito we know. And we heard that time and time again.
Thank you very much. Thank you, Mr. Chairman.
Thank you very much, Mr. Tober. Thank you, Ms. Tucker. Thank you, Mr. Payton. Senator Hatch.
I'll reserve my time, thank you.
Thank you. Senator Kennedy.
Thank you very much. Did you know, Mr. Tober, that the Vanguard Ventron, which is the case with 1992, actually involved the Carpenters, that names the Carpenters, which were on the Alito list for recusal. And
we
I think
weren't
for the most of the Mr. Payton, maybe this should be directed to you, and that most of the people that have looked through there in detail feel that the reason that was actually recused is because of the Carpenters. Or I think it's spelled Carpenters. C-A-R-P and Carpenter. And that was the reason it was under the name of the Vanguard. You're familiar with that?
Yes. I simply thought that it was unclear whether or not what would have caused that to be kicked off because of the standing recusal list was any hit with Vanguard or something else. It's unclear. You cannot tell from what is there.
Did the committee know when it inquired of the nominee that the Judge Alito had made a promise to the committee under oath that he was going to recuse himself from Vanguard?
Yes,
Yes,
and we asked him about that.
And did he indicate what was his response?
His response was that it was a mistake for those cases to have slipped through. That was not just a question about what the code said, but also what his representation to this committee encompassed, that it was a mistake.
And was the mistake, did you understand it, is because he didn't, for one reason or another, neglected to put the Vanguard on his recusal list?
No, I don't think I could say it that concretely. The mistake was that it got through. Why it got through, I think it was not completely clear to us. I'm not sure it was clear to Judge Alito. It got through.
Well, it wasn't on his 93, 94, 95, 96 lists. and the 93 says no changes were made from 92. So, and he got on the bench. You'd only been on, so there's just 1 year, year and a half.
Don't know
We
if
don't have
he
the
knew
record
that
on it,
then.
and I'm just wondering, in your inquiry and review of that case, since that is the principal source or as I understand it, of revenue. I mean, it's had sizable increases in the revenue from the time he took that oath till the more recent years. So that's one of the factors on it. And I was just interested when he said it was a mistake, whether it was, did you made a detection, because we have not been able to find that it was ever put on. And quite frankly, at least as a member of the committee, we've heard a number of reasons for it. We've heard computer glitch.
Yeah.
We've heard that it was an interim pledge and a commitment. We have heard that it was a pro se case, and therefore we didn't have the computers that don't exist in the circuit, Third Circuit, the way they do in law firms here in Washington, D.C. was the reason. And I'm just trying to find out what was told to you. I think, be very honest about it, if it had been said it was a mistake in the very beginning, I don't even think this issue would have taken more than 30 seconds of the committee's time. But since we've had so many different reasons for it, which we've been trying to ascertain exactly what had happened, and particularly since it was a pledge to the committee, and it was a sworn statement to the committee, that we were wondering what the Bar Association in
Senator
its
Kennedy,
interview.
I don't know the answer to your question. I don't believe that what you just said about what was on the list in 1993-94 was known then. I was unaware of that, and I'm not sure Judge Alito knew that. But in our discussion with him, we actually cut right through that and simply wanted him to tell us if he agreed this was a mistake. Did you just miss it? Yes, I just missed it. It was a mistake.
Well,
and the why then sort of became less significant.
Well, of course, Mr. Payton, he did. He changed. He took his during that same period of time, he took a name off the list. So he must have been familiar with it. He took the U.S. Attorney's name off the list. We went through this. I'd be glad to make available to the to you. You indicated that you'd gone through the hearings on this, and I'd welcome the opportunity just to make available to you the same material and to get your a response.
Senator, we indicated in our letter of explanation, as we always do, that we continue to monitor these proceedings.
Thank you.
And we'll be happy to revisit anything the committee wishes us to look at.
I want to join in thanking you for the service of the Bar Association. This is a very challenging and in many sense thankless job, but I think the country's much better off, and so is the judiciary, and I thank you for your service.
Thank you, sir.
No billable hours, Mr. Chairman.
Thank you, Senator Kennedy. Senator Hatch has stated an interest in regaining some of his reserve time.
Well, just shortly, we appreciate the efforts that you make. We appreciate what the Bar Association is doing, and we appreciate what you've done in this particular case as well. Now, you're aware that, and frankly, he did state right off the bat early in his testimony that he had made a mistake with regard to the Vanguard matter. On the other hand, are you aware that not only did he recuse himself once he realized he had made a mistake, but he asked the succeeding panel to retry the case. Are you aware of that?
Yes.
Yes.
Was that an appropriate thing to do?
He asked that the chief judge identify a new panel, and I think that was the appropriate thing to do.
And that's what an honest, decent judge would do, isn't it?
Sure, of course.
Now, you're all aware of this, of 28 U.S.C., the U.S. Code statute on this. Am I correct?
Correct.
I mean, that statute defines a financial interest for the courts. And it says financial interest means ownership of a legal or equitable interest, however small, or a relationship as director, advisor, or other active participant in the affairs of a party, except that ownership in a mutual or common investment fund that holds securities is not a, quote, financial interest, unquote, in such securities unless the judge participates in the management of the fund. You aware of that? Now, did he participate in the management of the fund? The answer is no. then if he didn't participate in the management of the fund, would he have had, under normal circumstances, to recuse himself?
Well, I think the normal circumstances is, amplified by the representation to this committee, which he acknowledged, independent of the obligation that you're talking about, would have caused him to not want these cases to come before him.
Right. But he made it clear that once he did realize that there was a mistake, even though he did not, according to this U.S. Code, which is the basis, did not have to recuse himself, he did so because he had said in his statement that he would.
Yes.
And you knew that. And so I take it you don't find any real fault in the way he handled the Vanguard matter.
Said so. That's correct.
That's correct.
That is correct.
Thank you so much.
Thank you, Senator Hatch. Senator Feinstein?
Thank you very much for your service. Have you heard anything in these hearings that would cause you any concern or reason to change any of your views?
Well, the hearings are still going, and I'm still listening. But to the moment, Senator, I have been looking for any kind of material or discordant statement that would have been inconsistent with anything that we have learned or heard either through our interviews or our meeting with the nominee. And to the moment, I'm still comfortable that we understood the judicial and legal profile of Judge Alito when we reached our rating.
Thank you. Thank you, Mr. Chairman.
Thank you very much, Senator Feinstein. Senator Kyle?
Mr. Chairman, I don't have any questions, but I would like to thank the panel and the Bar Association for its, I wonder how many hours of work put into verifying the qualifications of nominees, not just for the Supreme Court, but the other nominations, and particularly, Mr. Payton, your explanation of the matters that you testified to here. Thank you very, very much.
Senator DeWine?
No questions, Mr. Chairman.
Senator Sessions?
Mr. Tober, you have 15 members of your committee that goes out and they divide up the work and interview now 300 individuals. Is that what you did?
As it turned out, Senator, the chair just gets to do a lot of marshaling, and the Third Circuit representative had to recuse herself because she had argued a case before a panel that Judge Alito had served on before he'd been nominated, and the decision had yet to come down, so she, by our standards, removed herself. So I had 13 people out in the field interviewing well over 300 people, contacting over 2,000 people, putting together their own written reports, marshaling the information from every corner, and putting it in what turned out to be an 11-pound report. And when I first received it, as I told Ms. Tucker, I didn't know whether to read it or send out birth announcements.
Well, we're glad you don't have to do background work on senators. I can trust me.
We're pleased it's done.
Well,
for the moment.
One of the things, some of us have said we've complained about the ABA ratings, but there's so much value to it. It strikes me, because isn't it true that sometimes when you're interviewing a lawyer that's been before the judge, lost a case, or a lawyer who's litigated against them, they'll tell you things they may not come forward and say publicly, and that you can get a good you feel like you get a better perspective on a nominee's professional qualifications than you can get from reading the newspaper, perhaps?
Thank you for that question. Let me try and answer it. The answer is yes. We have had the experience since 1948, when we started reporting our ratings to this committee, of being able to get comprehensive, confidential information from people who know the nominee directly in the trenches, whether it be a judge, a lawyer, or other people in the community, and we are able to ask them with respect to integrity, professional competence, and judicial temperament, with the full and complete understanding that there will be no attribution, there will be no embarrassment, that if it's important, we need to know, and people indeed give us that kind of information. So yes, it is a remarkable process, and if I have the moment, I'd like to say it's a remarkable group of people that I've had the privilege to work with.
And Mr. Payton, you used the phrase that they held him in incredibly high regard. I think you're a premier litigator. You've argued before the Supreme Court. I'm sure you used those words carefully.
I did.
Well, I thank you for your service, and I think it has provided valuable insight to the committee, because you see these things out there, and it's important for the American people to know, what do the people who really know and work with this judge think about him? and we value your comments.
Thank you.
Thank you. Thank you, Senator Sessions. Senator Graham?
Thank you, Mr. Chairman. I'd just like to echo what my colleagues have said about the service you're providing, not only to the committee, but I think the country, because most people in the country are not lawyers. That's probably a good thing. The idea of who you're getting as a person is important, and the homework you've done gives us a good picture of this particular man. But his judicial experience compared to other people that you have reviewed, seems to me that being on the court for 15 years, you had a lot to look at.
Well, we don't compare one nominee to another, Senator, as I'm sure you can appreciate, but I will take the direct question, and indeed, I believe we said in our letter of evaluation that he's created an enormous record of public service, and his writings speak to that, and that's indeed what we've reviewed.
Well, thank you. And about your rating, you know, we're all very pleased to the outcome here. But democracy is about a process, not an outcome. The rule of law is about a process, not an outcome. And there may be an occasion where you render a rating I won't agree with, and that's just the way it goes. But I think the process where you're involved really helps us a lot. I think it helps the country, and I appreciate the time you've taken from your families and your business to do it. Now, what may take normal people 30 seconds to figure out may take the Senate 3 days. But we're gonna ask one simple question about Vanguard. I've listened, and with this much material to have dealt with in as many cases as he's heard, the first question for me about Judge Alito is, you know, who am I getting here? And is an innocent mistake okay? I hope so, because I make them all the time. What would I not want? I would not want someone who's into self-dealing. I would not want someone who skirts the ethical rules and plays as close to the line as they could. Would it be a fair statement that Judge Alito never plays close to the line? He tries to do it the best he can to take the highest approach to ethics?
I think that from what his colleagues who know him very well would say is that they hold him in the highest regard with respect to his integrity, and I think that encompasses what you just said.
Thank you very much. And one last thought about Vanguard. What is in it for him to intentionally hear the case knowing that he shouldn't? I have never found anybody that could give me a reason why this judge would make an intentional decision to avoid recusal when he should. Have you found a reason?
I actually am unaware of anyone who has claimed that he intentionally did this. It was a mistake.
And there's no benefit one could find for him intentionally doing it based on the nature of the case?
I'm not aware of one.
Thank you all for your
Senator, if I can
service.
just add, I believe it was Professor Rotunda who submitted a report to this committee, and I think there's a line in there that caught my attention. He said, reasonable people can make reasonable mistakes. And I think that captures what we thought we found, and when we spoke to Judge Alito about it, we were convinced that indeed had happened.
Again, thank you for your service.
Thank you, Senator Graham. Senator Schumer?
Thank you, Mr. Chairman. I just have a brief question, because we've heard a lot about the ABA rating, which is something that's prized and important. Your sheet here says it describes 3 qualities: integrity, professional competence, judicial temperament. Is that right?
That's correct.
Okay. So it would not at all get into what somebody's judicial philosophy would be, would it? Is that correct?
That's also correct.
And so if somebody were very far right or very far left, as long as they had integrity, professional competence, or judicial temperament, you would give them, if that's what you'd rate them on.
Senator, we don't do politics. What we do is integrity, professional competence, and judicial temperament. They are objective standards, and that's what we bring to this committee.
And if one standard was, however one defined it, if somebody was out of the mainstream, again, your rating would not give us any inclination whether that was part of it.
If the suggestion was that they were out of the mainstream politically, that's correct. If they're out of the mainstream because of judicial temperament, we might have a different thought.
Thank you.
Thank you very much, Mr. Tober, Ms. Tucker, Mr. Payton. We very much appreciate your service and your being here today.
Thank you.
Next call, next panel, Judge Becker, Judge Sirica, Judge Barry, Judge Aldiser, Judge Garth will be coming to us electronically, but he appears on the screen. Welcome, Judge Garth and Judge Gibbons and Judge Lewis. Pardon me, Senator Coburn, do you have questions of the ABA?
AMA, he'd like to ask about.
Yeah, he won't.
Can I have some water? I begin by welcoming the judges. By way of a brief introduction, I think it is worthy of comment how this panel came to be invited. Judge Becker was in my offices because since August of 2003, he has been performing mediation services on asbestos reform litigation. More than 40 meetings in a very, very tough legislative approach. And he was in my office last December, at a time when I was being interviewed by Kathy Kiley of USA Today. And I introduced Judge Becker to Ms. Kiley, who asked him about Judge Alito. And without objection, I'd like to make a part of the record the article which Ms. Kiley wrote for USA Today, dated December 14th, 2005, which contains Judge Becker's comments about Judge Alito. After that, I discussed with Judge Becker the possibility of his being a witness for Judge Alito. And after some discussions, Judge Becker checked out the various considerations, said he would be willing to do so if invited by the committee. And then Judge Becker talked to the other judges who were here today, who also stated a willingness to appear if invited by the committee, and I then sent them formal letters of invitation. Now to the judges. Judge Becker is a graduate of the University of Pennsylvania, 1954, Yale Law School, 1957, appointed by President Reagan to the District Court in 1970 and to the Court of Appeals for the Third Circuit in 1981. He's really been performing services as the 101st Senator. And by way of a full disclosure, I've known Judge Becker since the fall of 1950 when he was a freshman at the University of Pennsylvania and I was a senior. And we have been good friends ever since. Judge Becker, thank you for your service to the United States in so many capacities.
Thank you, Mr.
We
Chairman.
have a procedure for 5 minutes. I don't intend to bang the gavel on any of you judges, and not because you're judges, but because my gavel is almost broken. Judge Becker.
Mr. Chairman, Senator Leahy, and other members of the committee, Sam Alito became my colleague when he joined our court in 1990. Since that time, we have sat on over 1,000 cases together, and I have therefore come to know him well as a judge and as a human being. Many do not fully understand the intensity of the intellectual and personal relationship among appellate judges. We always sit together in panels of 3, and in the course of deciding and writing up cases, engage in the most rigorous dialogue with each other. The great violinist Isaac Stern, describing an afternoon of chamber music, once opined that after such a session, one knows his fellow quartet members better than a man knows his wife after 30 years of marriage. Now, this analogy, hyperbole aside, vividly describes the intense relationship among appellate judges. I therefore believe myself to be a good judge of the 4 matters that I think are the central focus of this committee as it decides whether to consent to this nomination: Sam Alito's temperament, his integrity, his intellect, and his approach to the law. First, temperament. Sam Alito is a wonderful human being. He is gentle, considerate, unfailingly polite, decent, kind, patient, and generous. He is modest and self-effacing. He shuns praise. When he had completed his 10th year of service on our court, Sam declined my offer, extended as Chief Judge, I was then the Chief Judge of the court, to arrange the usual party to observe 10-year anniversaries. Sam was uncomfortable at the prospect of encomiums to his service. Sam has never succumbed to the lure of big city lights. He has a sense of place, which for him is not nearby New York City, but New Jersey, which to him has always been home. Finally, there is an aspect of appellate judging that no one gets to see, no one, but the judges themselves, how they behave in conference after oral argument, at which point the case is decided, and which I submit is the most critically important phase of the appellate judicial process. In hundreds of conferences, I have never once heard Sam raise his voice, express anger or sarcasm, or even try to proselytize. Rather, he expresses his views in measured and temperate tones. Second, integrity. Sam Alito is the soul of honor. I have never seen a chink in the armor of his integrity, which I view as total. That opinion is not undermined by the furor over the Vanguard issue, by which I remain baffled. My wife holds Vanguard mutual shares, which I report on my financial disclosure form. However, I do not identify Vanguard on my recusal list because I am satisfied that my wife possesses no ownership interest in the Vanguard Management Company, which is what controls the recusal determination. She's never received a proxy statement, an opportunity to vote for directors, or any indicia of ownership other than her aliquot share and the fund to the extent of her investment. I believe that the view of Dean Rotunda, which is in your record, explains why Judge Alito was not required under the law to recuse himself in the suit against Vanguard. Third, intellect. Judge Alito's intellect is of a very high order. He is brilliant, he is highly analytical, and meticulous and careful in his comments and his written work. He is a wonderful partner in dialogue. He will think of things that his colleagues have missed. He is not doctrinaire, but rather is open to differing views and will often change his mind in light of the views of a colleague. Contrary to some reports, Sam does not dissent often. According to our court statistics, in the last 6 years, he has dissented only 16 times, a little over 2 cases per year. That's the same number that I've dissented, and fewer than the number of our colleagues. In my view, Sam Alito has the intellect to sit on the Supreme Court. I know all of its members. I know them reasonably well. In my view, he will be a strong and independent justice, his own man. Finally, Sam's intellect is not abstract, but practical. He does not mistake the obscure for the profound. Fourth, approach to the law. As I address this topic, I am acutely aware of the deep concern of the members of the committee about this subject. I am also aware that my role here is to testify to fact, not to opinion, and hence I will express neither normative or predictive judgments. The Sam Alito that I have sat with for 15 years is not an ideologue. He's not a movement person. He's a real judge deciding each case on the facts and the law, not on his personal views, whatever they may be. He scrupulously adheres to precedent. I have never seen him exhibit a bias against any class of litigation or litigants. He was a career prosecutor, but in the numerous criminal cases on which we have sat together, if the evidence was insufficient or the search was flawed, he would vote to overturn the conviction. And if the record did not support summary judgment against the plaintiff in an employment discrimination or civil rights case, he would vote to reverse. His credo has always been fairness. Now, I know that there's been controversy about certain ideological views expressed in some 20-year-old memos. Whatever these views may be, his judging does not reflect them. I think that the public does not understand what happens when you become a judge. When you take that judicial oath, you become a different person. You decide cases not to reach the result that you would like, but based on what the facts and the law command. What you decide as a judge are not general principles, but the case in front of you. You do it as narrowly possible. That's what Sam always does, with great respect for precedent. Sam Alito has been faithful to that judicial oath. Now, my final point relates to his approach to the law, another facet of his approach to the law. And the best calipers that I could find to measure his approach to the law was to compare it with my own. I haven't been a federal judge for 35 years, 1 week, and 1 day. My opinions would fill many bookshelves, but I think that I am fairly viewed as a mainstream or centrist judge. A computer survey run by our court librarian received 1,050 opinions in cases on which Sam Alito and I sat together. In these cases, we disagreed 27 times, which is probably about the same number that I would have disagreed with most other colleagues. Some cases turned on a reading of the record, others on how rigorously or flexibly we interpreted the reach of a statutory or constitutional provision or a state court's jurisprudence or applied our usually deferential standard of review. But in every case on which we differed, Sam's position was closely reasoned and supportable either by the record or by his interpretation of the law or both. Short of it, members of the committee, is that Sam Alito is a superb judge in terms of temperament, integrity, and intellect, and he has exhibited a careful, temperate, case-by-case approach to the law. Thank you for the opportunity to address you.
Thank you very much, Judge Becker. We now turn to Chief Judge Anthony Sirica, who, like Judge Becker, has known Judge Alito on the Third Circuit for the 15 years of Judge Alito's service there. Judge Sirica became Chief Judge in May of 2003, succeeding Chief Judge Edward Becker. Judge Sirica has a bachelor's degree from Wesleyan, 1962, Michigan Law School, 1965, appointed to the District Court by President Reagan in 1984 and to the Circuit Court and also by President Reagan in 1987. Thank you very much for coming in, Judge Sirica, and we look forward to your testimony.
Mr. Chairman, thank you very much. For the last 15 years, I have worked with Judge Alito. For 15 years, we have decided thousands of cases while serving on the same Court of Appeals. On most cases, we have agreed, but not always. Judges don't always agree on every case. As the Chief Justice remarked last summer, much like a baseball umpire, a judge calls balls and strikes. If the pitch is down the middle or way outside, the call is straightforward. But many pitches are on the corners, and then the calls are difficult. These cases require hard thought, and these are the cases where a judge earns his or her keep. In 15 years on the Court of Appeals, Judge Alito has more than earned his keep. He is a thoughtful, careful, principled judge who was guided by a deep and abiding respect for the rule of law. He is intellectually honest, he is fair, he is ethical. He has the intellect, the integrity, the compassion, and the judicial temperament that are the hallmarks of an outstanding judge. On 3 separate occasions, I spoke with a representative of the American Bar Association during its evaluation process. My views and those of my colleagues on the court were sought by the American Bar Association because we have a unique perspective on Judge Alito, a perspective that no one else has. Anyone can read and interpret his opinions, but we know Judge Alito from almost daily contact over a period of years. We have sat together in the same conference room. We have discussed the cases, we have decided them, and we have exchanged legal memoranda. Judge Alito approaches each case with an open mind and determines the proper application of the relevant law to the facts at hand. He has a deep respect for precedent. His reasoning is scrupulous and meticulous. He does not reach out to decide issues that are not presented in the case. His personal views, whatever they might be, do not jeopardize the independence of his legal reasoning or his capacity to approach each issue with an open mind. Like a good judge, he considers and deliberates before drawing a conclusion. I have never seen signs of a predetermined outcome or view, nor have I seen him express impatience with litigants or with colleagues with whom he may ultimately disagree. He is attentive and respectful of all views and is keenly aware that judicial decisions are not academic exercises, but have far-reaching consequences on people's lives. We admire him as a person. Despite his extraordinary talents and accomplishments, Judge Alito is modest and unassuming. His thoughtful and inquiring mind, so evident in his opinions, is equally evident in his personal relationships. He is concerned and interested in the lives of those around him. He has an impeccable work ethic, but he takes the time to be a thoughtful friend to his colleagues. He treats everyone on our court and everyone on our court staff with respect, with dignity, and with compassion. He is committed to his country and to his profession, but he is equally committed to his family, his friends, and his community. He is an admirable judge and an admirable person. Thank you, Mr. Chairman.
Thank you very much, Judge Sirica. We turn now to Third Circuit Judge Marianne Trump Berry, a graduate of Mount Holyoke, 1958, Columbia University in 1962, with a master's and a law degree from Hofstra, 1974. Judge Berry was in the U.S. Attorney's Office before Judge Alito was there, appointed to the District Court in 1983 by President Reagan, and to the Circuit Court in 1999 by President Clinton. She has worked with Judge Alito for the past 6 years as colleagues on the Third Circuit. Thank you for joining us, Judge Berry, and we look forward to your testimony.
Thank you, Mr. Chairman. Good afternoon, members of the committee. It is my privilege to appear before you, and it is a particular privilege to speak on behalf of my friend and colleague, Judge Samuel Alito. Now, I warn you, I may be a little free and call him Sam on occasion, because Judge Alito and I go back almost 30 years to 1977. 1977, Judge Alito came to the United States Attorney's Office in the District of New Jersey, following his clerkship with Judge Leonard Garth, who was and remains a giant on our court. Sam was assigned, to the Appeals Division, and I was the chief of that division, although in those days I didn't have very much more experience than he did. Now, I've said Appeals Division. That sounds very much more substantial than it was. For what it was 3 assistant United States attorneys working very, very hard at a very, very responsible job. We handled all the criminal appeals of those defendants who were convicted at trial. It was our job to master the record, to analyze the issues, to read the relevant cases, to write a persuasive brief on behalf of the United States, and, if necessary, to argue the case on the floor of the Court of Appeals. Nobody did it better than Sam Alito. And if there were any doubt on that score, the best evidence is the fact that after just 4 years as an assistant United States attorney, he went directly to the office of the Solicitor General. Only the best are able to do that. For the next 6 years, Judge Alito distinguished himself with public service in Washington, D.C. And then he returned to the District of New Jersey in 1987 as the United States Attorney. Important cases were brought on his watch: organized crime cases, drug trafficking cases, public corruption cases. I know, because I was there, and as a district court judge at that time, having been appointed by President Reagan, I handled some of his more important cases. Now, I mention the cases that were handled on his watch for another reason. The tone of a United States Attorney's office comes from the top. The standard of excellence is set at the top. Samuel Alito set a standard of excellence that was contagious. His commitment to doing the right thing, never playing fast and loose with a record, never taking a shortcut. His emphasis on first-rate work, his fundamental decency. The assistant United States attorneys who worked for him were proud to do so. They admired him completely. Now, of course, in 1990, Judge Alito became Judge Alito. And you have heard the most glowing things said about Sam as a colleague on our court. I embrace every glowing statement. Let me just conclude with this. Judge Alito was a man of remarkable intellectual gifts. He is a man with impeccable legal credentials. He is a fair-minded man, a modest man, a humble man, and he reveres the rule of law. If confirmed, Judge Samuel A. Alito, Jr. will serve as a marvelous and distinguished Associate Justice of the Supreme Court of the United States. Thank you, Mr. Chairman.
Thank you very much, Judge Berry. We turn now to Judge Rogera Aldisert, a bachelor's degree from the University of Pittsburgh in 1942 and law degree from the same institution in 1947 with intervening service in the Marine Corps. Served on the Court of Common Pleas of Allegheny County from 1961 to 1968, at which point he was appointed to the Third Circuit by President Lyndon Johnson. Judge Aldisert and I were reminiscing about my predecessor, Senator, he didn't get to be a judge, Senator Joe Clark, whose seat I now occupy. Was Chief Judge from 1984 to 1986 and took senior status in 1986. Has been an adjunct professor at the University of Pittsburgh and has served with Judge Alito on the Third Circuit for the past 15 years. Thank you for coming all the way from California, Judge Aldisert, to be with us today, and we look forward to your testimony.
Thank you, sir. Mr. Chairman and members of the committee, I thank you for this invitation to offer my views on my colleague. But before proceeding into my formal statement, I want the record to show that there was a discussion this morning about ages of judges. Well, I am an old man. And I'll tell you how old I am. There's a certain distinguished United States senator sitting up there who I swore in as a lawyer in the city of Pittsburgh over 40 years ago, and that's Orrin Hatch. And I will also say that I presided over the first jury trial that he ever tried, and he won the case. But I first testified.
That's sweet, Orrin.
I'm glad you said that, Judge. They don't believe it.
I never knew you won one. That's nice.
They've always gotten along very well together, Senator Leahy and Senator Hatch.
When I first testified before this committee in 1968, I was seeking confirmation of my own nomination to the Federal Circuit Court. I speak now as the most senior judge on the Third Circuit. And I begin my brief testimony with some personal background. In May 1960, I campaigned with John F. Kennedy in the critical presidential primaries of West Virginia. The next year, I ran for judge, as was indicated, and I was on the Democratic ticket, and I served 8 years as a state trial judge. And as the chairman indicated, Senator Joseph Clark of Pennsylvania was my chief sponsor when President Lyndon Johnson nominated me to the Court of Appeals. And Senator Robert F. Kennedy from New York was one of my key supporters. Now, why do I say this? I make this as a point that political loyalties become irrelevant when I became a judge. The same has been true in the case of Judge Alito, who served honorably in 2 Republican administrations before he was appointed to our court. Judicial independence is simply incompatible with political loyalties, and Judge Alito's judicial record on our court bears witness to this fundamental truth. I have been a judge for 45 of my 86 years. And based on my experience, I can represent to this committee that Judge Alito has to be included among the first rank of the 44 judges with whom I have served on the Third Circuit, and including another 50 judges on 5 other courts of appeals on which I have sat since taking senior status. Moreover, I have been a long-time student of the judicial process. I have written 4 books on the subject and more than 30 law review articles. And this study required me to study the current work of 22 justices of the U.S. Supreme Court. And I've read hundreds of opinions of appellate judges of every federal circuit, every state, and every political stripe. And the great Cardozo taught us long ago, the judge, even when he is free, is not wholly free. He is not to innovate at pleasure. This means that the crucial values of predictability, reliance, and fundamental fairness must be honored. And as his judicial record makes plain, Judge Alito has taken this teaching to heart. He believes that legal outcomes will follow the law as dictated by the facts of the particular case, whether the facts involve commercial interests, government regulation, or intimate relationships. According to these criteria, Mr. Chairman, Judge Alito is already a great judge. We who have heard his probing questions during oral argument, we who have been privy to his wise and insightful comments in our private decisional conferences, we who have observed at first hand his impartial approach to decision-making and his thoughtful judicial temperament and know his carefully crafted opinions, we who are his colleagues are convinced that he will also be a great justice. If Judge Alito is confirmed, as I believe wholeheartedly he deserves to be, he will succeed a justice who has gained a reputation as a practical justice, whose resistance to ideologically driven solutions has positioned her as a swing vote on the court. And as has been heard several times in this hearing, Justice O'Connor in 1995 described her approach to judging. What she said then is even more important today. And I quote, "It cannot be too often stated that the greatest threats to our constitutional freedoms come in times of crisis. The only way for judges to mediate these conflicting impulses is to do what they should do anyway. Stay close to the record in each case that appears before them and make their judgments based on that alone." And knowing Sam Alito as I do, I am struck by how accurately these words also describe the way in which he has performed his work as a United States Circuit Judge. And that is why, with utmost enthusiasm, I recommend that he be confirmed as an Associate Justice on the Supreme Court. And thank you, Mr. Chairman.
Thank you very much, Judge Alito. We now turn to Judge Leonard Garth, who's coming to us. You see him on the television screen, coming to us from California. Judge Garth is a graduate of Columbia, 1942, served in the United States Army, lieutenant from 43 to 46, and then from the Harvard Law School, where he graduated in 1952. In 1969, he was appointed to the District Court by President Nixon, and then to the Circuit Court by President Nixon in 1973, a lecturer at Rutgers Law School and at the Seton Hall Law School. Has known Judge Alito since Judge Alito clerked for Judge Garth back in 1976 and 1977, and has served with him on the Third Circuit for the 15 years of Judge Alito's tenure there. Judge Garth, we very much appreciate your being with us, and we look forward to your testimony.
Thank you, Senator Specter, Senator Leahy, and the honorable members of the Senate Judiciary Committee, and of course my own family of judges who have preceded me in speaking to you today. I too am privileged to appear before you today, albeit by video conferencing rather than in person. I cannot be with you in person because I recently had some major spinal surgery, and I find it extremely difficult and painful to travel. As Senator Specter has indicated, I have served as a federal judge for some 36 years, as a district court judge in New Jersey, and since August of 1973 as a member of the Third Circuit Court of Appeals. Now, I do want to interject and say that in that respect, Perhaps Judge Alito is older than I am, but not by many days. And I am almost as old as he is, but not quite as handsome as Judge Barry of my court. I hope you'll forgive that aside, but I want to ask you for something else to forgive me. I have heard all of my colleagues speak so eloquently, and I'll use the term that Judge Barry used glowingly about Judge Alito, but I have known him just a little bit longer and in a different capacity over the course of his career. Following his graduation from law school, he served as one of my two law clerks in 1976 and 1977. And as you have heard, since 1990, he has served as my colleague on the Court of Appeals. During the interim years, because of the relationship that we developed during his clerkship and the fact that both he and I are New Jersey residents, we remain close to one another. Hence, I think I can speak knowledgeably about Sam's qualifications and his talents, his discretion, his honesty, his fairness, and his integrity. These are qualities that Judge Alito possesses now and has possessed since the very beginning of his legal career. Let me first tell you about Sam's clerkship with me. As you may know, a law clerk is a judge's legal advisor and a sounding board, if I may use that term. But he or she often becomes much more than that, a member of the judge's extended family. And as a result, a judge gets to know his law clerk in a particularly personal way. I knew Sam in this personal way at the very beginning of his career as a lawyer. For that reason, I think I have a unique perspective to share with you about him. I chose Sam to be my law clerk in 1976 from among the literally hundreds of applicants who sent their resumes to me and the other judges of honor of our court on that year. Sam was still a law student when I interviewed him, but he struck me in that encounter as fiercely intelligent, deeply motivated, and extremely capable. I did not know at that time that Sam was the son of Samuel Alito Sr. That's a gentleman who had impressed me very, very much as a witness in the New Jersey district redistricting case that I heard about 1972. Once I made the connection, however, I fully understood why Sam was so impressive and why he regarded and regards today his father as a role model. During his tenure with me, Sam bore out all my initial impressions of his excellence, impressions which had led me to engage him. He was a brilliant and exceptional assistant to me. He enabled me to test judicial theories and to fashion appropriate judgments in each case that came before our court. I have had some 85 law clerks assisting me in chambers over the course of my career in the bench. They have all been extremely well qualified in all ways to serve a Court of Appeals judge. Sam Alito stands out even among that very elite group. And during the year that he was my law clerk, Sam and I frequently took an afternoon walk near the courthouse in Newark and discussed the cases while we walked. I can tell you that the recommendations and arguments that Sam made about those cases were, as my colleagues have pointed out, always reasoned, principled, and supported by precedent. I developed then a deep respect for Sam's analytical ability, his legal acumen, his judgment, his institutional values, and yes, even his sense of humor, which, if he is confirmed, as I hope he might be, will probably compete with that of other justices. Few of the cases that come before our court are slam dunk cases. Most involve difficult questions on which reasonable people can disagree, and generally Sam and I reached agreement after discussing these cases, but more than once we did not. Even in those latter cases, the ones in which we disagreed, I understood and respected the positions that Sam advanced and the contours of his analysis. Our afternoon walks invariably ended at the neighborhood store, T.M. Ward Company, where we purchased peanuts and coffee. I note parenthetically that Ward's has since honored Sam by naming a special blend of coffee that he favors, Judge Alito's Bold Justice Blend. I think there are a few of us that have that distinction. After he left my chambers, Sam continued on to public service, as you have heard. In a letter to the then Deputy Assistant Attorney General Arnold Burns, I endorsed Sam's candidacy for United States Attorney for the District of New Jersey, and I want to just read you what I wrote. This was a long, long time ago. I can certify to Mr. Alito's integrity, ability, discretion, and honesty. Above and beyond those qualities, however, I believe his talents as a lawyer are exceptional. I am sure that his tenure in government service since he has left my chambers has reflected the fact that he is a thorough, meticulous, intelligent, and resourceful attorney, and that his judgments are mature and responsible. Indeed, he was one of the finest law clerks I have had the privilege to engage. And if I were to rate him on the basis of 1 to 10, 10 being the highest rating, he would without question receive a 10+ rating. I stressed these same attributes when I endorsed Sam for membership on our court 7 years later. He has more than lived up to my rating and the qualities that I attributed to him in the 15 years since he joined the court and became my colleague. Sam is an intellectually gifted and morally principled judge. We have not always agreed on the outcome of every case, as I have just recently stated. Just this fall, for example, Sam dissented from a majority opinion that I wrote in an Employee Retirement Income Security Act, that's ERISA, that I wrote in an ERISA case. In that case, Sam and I disagreed about how two provisions of the statute interact. I and the other majority judge were attracted in large part to the reasoning of the Second Circuit. Judge Alito, on the other hand, was attracted by the reasoning of the Seventh Circuit. Even in the cases on which we disagree, however, I always respect Sam's opinion, just as I did during our afternoon walks when he was my law clerk. Sam is also a prudent judge. Make no mistake, he is no revolutionary. He is a sound jurist, always respectful of the institution and the precepts that led to decisions in the cases under review. I have heard concerns expressed about whether Judge Alito can be fair and even-handed. Let me assure you from my extensive experiences with him and with my knowledge of him going back, as I have stated, over 30 years, that he will always vote in accordance with the Constitution and laws as enacted by Congress. His fairness, his judicial demeanor and actions, and his commitment to the law, all of those qualities which my colleagues and I agree he has, do not permit him to be influenced by individual preferences or any personal predilections. As you may know, when the judges of our court meet in conference, and I think Judge Becker referred to this in his remarks, we are the only individuals in chambers no law clerks, no assistants, no administrative personnel, or indeed anyone else attend these conferences. I can tell you with confidence that at no time during the 15 years that Judge Alito has served with me and with our colleagues on the court, and the countless number of times that we have sat together in private conference after hearing oral argument, has he ever expressed anything that could be described as an agenda, nor has he ever expressed any personal predilections about a case or an issue or a principle that would affect his decisions. He has a deep and abiding respect for the role of stare decisis and established law. I appreciate, of course, that the Supreme Court can retreat from its earlier decisions, but it does so rarely and only in very special circumstances. And I am convinced that if Judge Alito is confirmed as an Associate Justice of the Supreme Court, he will continue to honor stare decisis as he did as a law clerk and as he has done as a member of our court. He will sit among those jurists whose qualities of fairness and of principles are the lodestar of the judiciary. In my opinion, Sam is as well qualified as the most qualified justices currently sitting on the Supreme Court. A word about Sam's demeanor is in order. Sam is and always has been reserved, soft-spoken, and thoughtful. He is also modest, and I would even say self-effacing. And these are the characteristics I think of when I think of Sam's personality. It is rare to find humility such as his in someone of such extraordinary ability. Over the 30 years I have known Sam, I have seen him grow professionally into the reserved, mature, independent, and apolitical jurist that graces our court today. I regard him as the most qualified member of our court to be considered as an Associate Justice of the Supreme Court. I know that just as Judge Alito has brought and brings grace and luster to the Third Circuit, so too will he bring grace and luster to the United States Supreme Court if he is confirmed. Thank you, members of the Senate Judiciary.
Thank you very much, Judge Garth. Coming from us, I've just been advised from Phoenix, Arizona. Thank you. Our next witness is Judge John Gibbons, graduate of Holy Cross, 1947 bachelor's, Harvard Law School in 1950, nominated to the Third Circuit by President Nixon in 1970, chief judge from 1987 to 1990, at which time he resigned to become a professor of law at Seton Hall University. He now is in the practice of law, known Judge Alito for more than 20 years when Judge Alito was U.S. Attorney and has tried cases before Judge Gibbons. Thank you very much for being with us today, Judge Gibbons, and we look forward to your testimony.
Mr. Chairman and members of the Judiciary Committee, as you all probably know, or as Senator Specter has just said, I was a member of that Court of Appeals where Judge Alito was now a member for 20 years, and indeed it was my retirement from that court 16 years ago that created the vacancy which Judge Alito filled on the Court of Appeals. Since his appointment, lawyers in the firm of which I'm a member have been regular litigators in the courts of the Third Circuit, not only on behalf of clients who pay us handsomely for such representation, but also frequently through the firm's Gibbons Fellowship Program on behalf of non-paying clients whose cases have presented those courts with challenging human rights issues. The Gibbons Fellowship Program is certainly a significant part of our practice, as amply demonstrated by the fact that since 1990, Gibbons Fellows lawsuits have resulted in 115 reported judicial decisions. This committee should appreciate that the Court of Appeals for the Third Circuit has been, for the 50-plus years that I've followed or participated in its work, a centrist legal institution. An important reason why that's so is that many years ago the court adopted the requirement that all opinions intended for publication must, prior to filing, be circulated by the opinion writer not only to the members of the three-judge panel, but also to the other active judges on the court. The purpose of this internal operating rule was to permit each active judge not only to comment upon the opinion writer's treatment of Third Circuit and Supreme Court precedent, but also to vote to take the case en banc for rehearing by the full court if the judge thought that the opinion was outside the bounds of settled precedent. Thus, the level of interaction among the Third Circuit appellate judges has, for a half-century, been unusually high. This committee should also appreciate that appointment to an appellate court where one has life tenure is a transforming experience. I remember a former judicial colleague saying to me once after several years on the bench, "John, what other job in the world is there in which you can look in the mirror while you're shaving and say to yourself, all I have to do today is the right thing according to the law?" A good judge puts aside interests of former clients, interests of organizations one may have belonged to, and interests of the political organization that may have been instrumental in one's appointment. I personally experienced that transformation, and I witnessed it repeatedly in the judicial colleagues who joined the court after I did. These 2 points, the unusual internal cohesion of the Third Circuit Court of Appeals and the transformative experience of serving on a court protected by life tenure, suggests to me that the committee members, in determining whether or not to vote in favor of confirming Judge Alito, should concentrate not on what he thought or said as a recent Princeton undergrad or graduate, or as a young lawyer seeking advancement as an employee of the Department of Justice, but principally, if not exclusively, on his record as an Article III appellate judge. If you look, as you should, at that 15 record as a whole, you cannot in good conscience conclude that Judge Alito will bring to the Supreme Court any attitude other than the one held by the colleague I mentioned who thought important thoughts about judging every morning while he was shaving. He has consistently followed the practice of carefully considering both Supreme Court and Third Circuit precedents. Very few of the opinions he has written for a unanimous panel or for a panel majority have moved his colleagues among the active judges to vote to take the case en banc. The cases in which he participated that produced dissenting opinions by him or from him, all, it seems to me, were close cases in which either the law or the evidentiary record were such that equally conscientious judges could quite reasonably disagree about the outcome. Take, for example, cases presenting challenges to state regulations of abortion, certainly a hot-button topic for many people who are opposing Judge Alito's confirmation. I found 4 such cases in which he participated. In 3 of them, he decided against state regulations that might have put a burden on a woman's choice for abortion. for an abortion. In the fourth case, about which a lot has been said, Planned Parenthood of Southeastern Pennsylvania v. Casey, Judge Alito dissented from a majority opinion holding unconstitutional the Pennsylvania spousal consent provision for an abortion. And it is that dissent which the opponents of his confirmation talk about most frequently. They seem to urge that on the basis of that dissent, Judge Alito is so far out of the mainstream of constitutional law that his confirmation will endanger the constitutional protection of civil rights practically across the board. In your consideration of that dissent, I suggest that you should take into account these points. First, at the time the circuit considered the Pennsylvania spousal consent statute, the Supreme Court had not yet decided whether states could impose such a requirement. And second, the Court of Appeals majority invalidated the statute. Had the Supreme Court simply denied certiorari, that invalidation would have remained in place. Instead, at least 4 justices voted to grant certiorari. If the issue of the statute's constitutionality was so overwhelmingly clear, why was certiorari granted to endorse the Third Circuit's majority position? Clearly, Planned Parenthood v. Casey was, at the time of the Court of Appeals acted, a case over which conscientious judges could reasonably disagree. Otherwise, the Supreme Court would simply have denied certiorari. Nothing in the Supreme Court's case law dealing with abortion relieves the appellate judges in intermediate appellate courts from the duty of making a conscientious effort to fit the case before them within that case law. And the 4 abortion cases in which he participates show that that is exactly what Judge Alito has done. Another opinion that has caught the attention of those clamoring for Judge Alito's scalp is his dissent in United States v. Rybar, in which he would have held that the Supreme Court decision in Lopez prohibited Congress from regulating mere possession of machine guns. The majority opinion upheld the statute. Unlike Casey, the Supreme Court didn't review that case. Thus, the question of the reach of Lopez was left open. And when the issue reached the Ninth Circuit in United States v. Stewart in 2003, it adopted Judge Alito's dissenting position. Some opponents of his confirmation have relied on that dissent in suggesting that Judge Alito is perhaps a captain of the right-wing gun lobby. This committee, after actually reading Lopez and Rybar and the Ninth Circuit case, I suggest, cannot in good conscience find the dissent to be anything more than a good faith effort to somewhat unenthusiastically apply the perhaps unfortunate Supreme Court precedent of Lopez. Indeed, in his Rybar dissenting opinion, Judge Alito suggested how Congress could cure the Lopez violation. The extent to which opponents of Judge Alito's confirmation largely ignore his overall 15-year record as a judge suggests, at least to me, that the real target for many of the somewhat vitriolic comments on the nomination is less him than the executive branch administration that nominated him. The committee members should not think for a moment that I support Judge Alito's nomination because I'm a dedicated defender of that administration. On the contrary, I and my firm have been litigating with that administration for a number of years over its treatment of detainees held at Guantanamo Bay, Cuba, and elsewhere. And we are certainly chagrined at the position that is being taken by the administration with respect to those detainees. It seems not unlikely that one or more of the detainee cases that we are handling will be before the Supreme Court again. I do not know the views of Judge Alito respecting the issues that may be presented in those cases. I would not ask him, and if I did, he would not tell me. I'm confident, however, that as an able legal scholar and a fair-minded justice, he will give the arguments, legal and factual, that may be presented on behalf of our clients, careful and thoughtful consideration without any predisposition in favor of the position of the executive branch. That's more than the detainees have received from the Congress of the United States, which recently enacted legislation stripping federal courts of habeas corpus jurisdiction to hear many of the detainees' claims without even holding a committee hearing. Justice Alito is a careful, thoughtful, intelligent, fair-minded jurist who will add significantly to the court's reputation as the necessary expositor of constitutional limits on the political branches of the government. He should be confirmed.
Thank you very much, Judge Gibbons. Our final witness on the panel is former Third Circuit Judge Tim Lewis, a graduate of Tufts University in 1976, a law degree from Duquesne in 1980. He served as an assistant United States attorney before President Bush the Elder appointed him to the Western District Court, and then in 1992, President Bush the Elder nominated him to the Third Circuit. Judge Lewis resigned in 1999 and now is co-chair of the appellate practice group at the Schneider-Harrison office. He serves as co-chair of the National Committee on the Right to Counsel, a public service group dedicated to adequate representation of indigents. Judge Lewis and Judge Alito served together on the Third Circuit for 7 years. We appreciate your being here, Judge Lewis, and the floor is yours.
Thank you very much, Senator Specter. Thank you, members of the committee. It's a pleasure and an honor to be here today. When Thurgood Marshall announced that his intention to resign as a justice of the United States Supreme Court in conference one day, the first person to respond was Chief Justice Rehnquist. Chief Justice Rehnquist's words were, "No, Thurgood, no, please don't. We need you here." Shortly thereafter, when Justice Marshall had resigned, he was interviewed, and in the course of that interview was asked about Chief Justice Rehnquist. And during that interview, he said, "This is the best chief that I have ever served under," and went on to extol Chief Justice Rehnquist, his service as on the United States Supreme Court. Now, I was quite frankly stunned by both of those observations when I learned them at the time. And it wasn't until I had served for a period of time as a judge on the United States Court of Appeals that it all began to make sense to me. It is no coincidence to anyone who is familiar with my body of work while I served on the United States Court of Appeals and my body of work since having left the court that I happen to be sitting on the far left of this panel here this afternoon. And yet I am here. And what I have just related about the exchanges between Justice Marshall and Justice Rehnquist and Justice Marshall's later observation about the Chief Justice helps explain why I am here. Because it is true that during the time that I served with Judge Alito, there were times when we did not agree. I am openly and unapologetically pro-choice and always have been. I am openly and it's very well known, a committed human rights and civil rights activist, and am actively engaged in that process as my time permits, my law practice permits today, and through my law practice at Schneider, Harrison, Siegel, and Lewis. I am very, very much involved in a number of endeavors that one who is familiar with Judge Alito's background and experience may wonder, well, why are you here today saying positive things about his prospects as a justice on the Supreme Court? And the reason is that having worked with him, I came to respect what I think are the most important qualities for anyone who puts on a robe, no matter what court they will serve on, but in particular the United States Supreme Court. And first and foremost among these is intellectual honesty. As Judge Becker and others have alluded to, it is in conference, after we have heard oral argument and are not propped up by law clerks, we are alone as judges discussing the cases, that one really gets to know, gets a sense of the thinking of our colleagues. And I cannot recall one instance during conference or during any other experience that I had with Judge Alito, but in particular during conference, when he exhibited anything remotely resembling an ideological bent. That does not mean that I agreed with him, but he did not come to conference or come to any decision that he made during the time that I worked with him based on what I perceive to be an ideological bent or a result-oriented demeanor or approach. He was intellectually honest, and I would say rigorously so, even with respect to those areas that he and I did not agree. Second, I have no hesitation in commending his commitment to principle, both in how he went about his work on the Third Circuit, how he came to his decisions. It was through a very difficult process. We all would put ourselves through, but in Sam's case, I think that I can say that there's no one worked harder at coming to what he thought was the right decision than Judge Alito. And finally, though we did disagree, it was always respectful. And that is what I came to understand as probably the most important facet of appellate judging. No one, and I mean no one, has a corner on the marketplace of ideas in terms of what is best, what is right. We have different approaches, and it's very important that we maintain different approaches in positioning and in pushing forward our sense of our jurisprudence. They do not have to be the same. They do. In fact, I think that it is contrary to the best interests of democratic government for there to be some monolithic approach to judicial decision-making on the United States Supreme Court or on any other court. Sam Alito practiced a form of jurisprudence that I think is best referred to as judicial restraint, judicial deference. It is in many respects, a more conservative form of jurisprudence than was my own. And that is fine. That is perfectly fine. And as a matter of fact, I dare say it's important because through the exchanges we learn from one another, and I think we're a better court. And I know that this is the case on the Supreme Court as it is reflected in Chief Justice Rehnquist's observation when Justice Marshall announced his resignation. And I think that it's important that different approaches be respected. So that in the end, I am here as a matter of principle, and as a matter of my own commitment to justice, to fairness, and my sense that Sam Alito is uniformly qualified in all important respects to serve as a justice on the United States Supreme Court. Thank you.
Thank you very much, Judge Lewis. This panel, this distinguished panel, has been accorded much more time that we customarily allow because of the very large number of witnesses which we have, but out of deference to your positions and your coming here and your unique knowledge, we have done that. I would like to ask each of you a great many questions, but I'm going to limit myself to 5 minutes. And I would urge that the responses be sound clips. You haven't had as much experience with that as we have, but on the networks, the sound clip goes for about 8 seconds and locally about 18 seconds. You don't have to quite do that, but as close as you can. You can start my clock now. Judge Becker, the conference is a unique opportunity, as has been explained, to really find out about what your colleagues think. Do you think, is your judgment, that Judge Alito would allow his personal views on a matter to influence his decisions as a justice?
I do not think that. I am confident that he would not.
Judge Garth, you spoke about stare decisis. You have been quoted about your views of Judge Alito as to his approach, if confirmed, where the bounds of a Supreme Court justice on stare decisis are not the same as a Court of Appeals judge. As Judge Gibbons has noted, the issue of a woman's right to choose has become a very central factor in our deliberations. Do you have any insights which you would care to offer as to how Judge Alito would weigh the issue of stare decisis on that particular subject?
I can only say that I've heard Judge Alito speak as to how he would approach and process any judicial problem. And it would be presumptuous of me to even think of how he would rule on that subject. But I can tell you that when it comes to applying the precedents in our court and of the Supreme Court, he has always been assiduous in the manner in which he has applied them, and he has always had good reason and principle. I can't say more than repeat again that I believe that Judge Alito, when he described to the committee how he would rule on a case and what he would do in respect of stare decisis, I could not express it better than he did.
Judge Barry, you've sat with him in these private conferences, known him for a long time, back to days when you were and I hadn't noted that, you were in the U.S. Attorney's Office when he was an assistant. How would you evaluate Judge Alito on his consideration of women's issues?
If I had to add anything to my initial testimony, I would have stated more about what Sam and I did together on this wonderful court, and how reasonable he was, and how he never indicated bias of any kind. I told you at the outset, I have known Judge Alito for almost 30 years. I have the utmost respect for him. I have never heard him say one thing that would give me any reason to believe that he would give other than the most careful consideration to what you described as women's issues.
Judge Lewis, have a question for you, and then I'm going to propound a question for the other three judges before my red light goes on. I would like you to be a little more specific in your evaluation on Judge Alito as to how he would handle the civil rights issue. And I'm not going to wait for you to start to answer because my red light will go on in advance. And then I'm going to ask Judge Sirica, Judge Aldister, and Judge Gibbons to address the subject which has concerned this committee in some detail as to whether there is any tilt in Judge Alito's approach to the powerful, to the government, as opposed to the average citizen, whom we characterize as the little guy. Would you start, Judge Lewis, with your evaluation?
Yes, I will. Thank you, Senator. Let me begin by saying that if I believed that Sam Alito might be hostile to civil rights as a member of the United States Supreme Court, I guarantee you that I would not be sitting here today. That's the first thing that I want to make clear. My experience in civil rights cases on the Third Circuit were primarily in the Title IX or Title VII area, and with Judge Alito. And there were cases in which we agreed and cases where we disagreed. There was one in particular, the Piscataway case, which was, for lack of a better term, a reverse discrimination case that became an en banc matter, where I and a number of my colleagues wound up writing dissenting opinions, but that was a very close and I think very closely contested case having to do with whether or not Title VII contemplated diversity as an interest that an employer could use, to my disagreement and chagrin, the majority did not agree with Judge Slovert or Judge McKee and myself in that case. But I never felt that Judge Alito was, or any of my colleagues who were in the majority in that case, were in any sense hostile to civil rights interests. This is a legal question, and they came out the way that they did. In other cases, for example, the Amon versus Court Furniture case, which I authored, Judge Alito was not on the panel, but as I think Judge Gibbons mentioned, all cases, all opinions are circulated on the Third Circuit, and so really any opinion that comes out is the opinion of the court. I don't believe in that case, which was another Title VII case that I think furthered the law in some very important respects, defining code words as racial code words as actionable under Title VII. I believe that Judge Alito went along with that. I was very happy that he did that, and there were others. My sense of civil rights matters and how courts should approach them jurisprudentially might be a little different. I believe in being a little more aggressive in these areas, but I cannot argue with a more restrained approach. As long as my argument is going to be heard and respected, I know that I have a chance, and I believe that Sam Alito will be the type of justice who will listen with an open mind and will not have any agenda-driven or a result-oriented approach.
Judge Sirica, would you reply as briefly as you can as to the question I posed?
In my 15 years with Sam Alito, I have never seen any indication that he would favor that particular interest.
Judge Aldister?
Well, I'd approach it from a rather personal standpoint. Judge Alito is an American of Italian origin, and until quite recently, the Americans of Italian origin were subject to a lot of discrimination. Quotas as to whether they could get into professional schools. A little example in my particular case, when you consider all the Americans of Italian origin from New England, Connecticut, New York, New Jersey, Pennsylvania, and along the seaboard, there had never been an American of Italian origin where these millions of Americans of Italian origin lived. There had never been an American of Italian origin ever appointed to the United States Court of Appeals until President Johnson appointed me in 1968. So I can speak from experience Things are better now, but I have lived through that. When you look at Judge Alito, his father came to the United States as an Italian immigrant, very early age, and I'm certain that the idea of protecting the rights of the so-called little guy is in the genes of Samuel A. Alito, Jr.
Judge Gibbons, as briefly as you can.
Well, his attitude toward criminal defendants is of some significance for our law firm because we have a very big white-collar criminal defense practice. And my partner, Larry Lutzberg, prepared a memo on the subject. He says, although given his prosecutorial background, Judge Alito has been seen by many of the defense bar as pro-government, a thorough review of his record shows that, in fact, he's a fair-minded jurist who pays careful attention to the record below and who takes great pains to apply precedent. Now, he then goes on in the memo to review the series of cases in which Judge Alito decided against the government on many significant issues. And he concludes, while like most appellate judges, there are far more decisions affirming than reversing convictions. That is certainly true of every judge who's sat on the Court of Appeals. Judge Alito's jurisprudence is properly characterized as careful, based on precedent, and particularly attentive to the record. If that record does not support affirmance, he reverses. But he also included an admonition to the rest of the department that you better know the record because he will.
Thank you, Judge Gibbons. Senator Feinstein.
Thank you very much, Mr. Chairman, and I'd like to thank you very much for being here. I think the testimony was very interesting. I listened acutely. And, you know, I think we'd all be very lucky if any one of us had colleagues like you that would come forward and say the things that that you all have said. Let me ask this question, and how do you look at the evaluations that have been done? Those evaluations that say, well, in the cases looked at, he is judged whatever percent it was, but let's say it's 70%, I'm just making it, in favor of corporations or business or against the little man. How do you look at that sample and how do you regard that? It's been written about rather extensively. Anyone that would like to try to answer it?
Well,
Judge Becker?
I would try that.
Oh, all right. Give Judge Becker, because I've known him longer.
Senator Feinstein, first of all, you have to keep in mind that, and I think this is a national, this statistic applies nationwide. I think somewhere between 80 and 85% of cases are affirmed. So a lot of this is going to determine who won in the district court or who won in the agency. So those numbers are skewed by that very fact. The only other thing I would say is I haven't analyzed these statistics, but that's nothing I've ever seen. Now, he's voted with me. There was a case not long ago. It was a very thin employment discrimination case, which a woman law she never got to a jury in district court. One of my colleagues wanted to affirm. I was on the fence, and Sam wanted to reverse. I said, okay, write it up, and we went along. I've just never seen any evidence that he's for the big guy against the little guy. But I think if you analyze these, I think you'd find most of the statistics come from the fact that the big guy won in the district court, and 80 to 85% of those cases are affirmed, and most of those would have been unanimous.
I was about to say the same thing, but my good friend Judge Becker, your figure was a little skewed there. The percentage of reversals is not 15%, it's 8.7% under the statistics of last year of all cases. In criminal cases, in the figures of 2004, The reversal rate in criminal cases was 5.1%.
I always defer to the master Oliver.
And of course, it should be added that when we are considering cases on appeal, we are operating on a standard of review. So we are not typically looking at the issues giving
Underlying the review
Yeah,
situation, right?
That's right. We're looking at an abuse of discretion standard. We're looking at were the facts clearly erroneous. So we're not starting from scratch, typically.
Let me ask you this question. The subject of abortion and Roe was raised, and obviously if you've listened to the hearings, you've heard the questioning going on back and forth. I was very puzzled when I read Chief Justice Roberts' statement before us on Roe and how he answered Senator Specter's questions. And the Chief ended up by saying that he felt that Roe was well-settled law. I think he even added to that, very well-settled law.
He said settled beyond that.
Oh, all right, settled beyond that. And I asked Judge Alito, and I thought at the very least he was going to agree with Justice Roberts. And he said, well, it all depends upon what settled means. What do you make of that?
I respectfully cannot characterize what Judge Alito meant by that. And I much prefer not to have to try.
That's fine. Anybody?
I think we're here as fact witnesses more than opinion witnesses, Senator Feinstein. And I really wouldn't know how to answer that question. I
Very good.
couldn't make a judgment on it.
Very good. Thank you. Thank you very much. Thanks, Mr. Chairman.
Senator Hatch.
Well, I want to express my gratitude to all of you judges, you two out there in the West, Judge Garth, for coming here today and helping this committee. It was pretty apparent that I got quite emotional when my old friend Judge Alito testified. I really did. I got emotional because I care for you. And I watched you for years there and just have a tremendous amount of respect. I've read your books, and you've always sent them to me. And that's meant a lot to me. But you all mean a lot to me. It's no secret that with very few exceptions, I love the federal courts. I love the judges. And there are very few exceptions. There are a few that I think you can name yourselves. But by and large, you know, we pass unconstitutional legislation up here all the time. The president sometimes do. If it hadn't been for the courts, we would probably not have preserved the Constitution. So I want to give you all credit for that. But let me just say this. By the way, just to correct the record, now Chief Justice Roberts, he and Judge Alito basically said the same thing. They said, well, it's settled as a precedent of the court with regard to Roe versus Wade. That's exactly what he said. Entitled to respect under principles of stare decisis. That's basically what Alito said. And when Senator and he said it, and Robert said it, and it is settled as a precedent of the court. Yes. So Senator Specter asked him some more, and then he said, I think the initial question for the judge confronting an issue in this area, you don't go straight to the Roe decision. You begin with Casey, which modified the Roe framework and reaffirmed its central holding. So these are maybe touchy words, but it's important to get it right. Now, one of the most prominent issues in this hearing has been how Judge Alito views the role of precedent in deciding cases. Too often, I think, the objective seems not so much to get insight into Judge Alito's general views about precedent, but clues about how he will treat particular precedents. First, let me make this point about Judge Alito's record regarding circuit precedent. As I understand it, the appeals court can reconsider its own precedents only when all Third Circuit judges sit together en banc. Is that correct?
That is correct.
Okay. It is my understanding that in his 15 years on the Third Circuit, Judge Alito has participated in 38 en banc decisions. Now, Judge Alito voted to overturn circuit precedent in just 4 of those cases. 2 of those decisions were unanimous. All judges agreed. Now, that does not look to me like someone who plays fast and loose with precedent. Now, let me just ask you, Judge Becker, and if anybody disagrees with what Judge Becker says, I'll be happy to have you respond. Let me ask you a question about Judge Alito's handling of certain, and the reason I asked Judge Becker is, as Senator Specter says, the 101st senator. He came down here and gave beaucoup time trying to help this asbestos problem, and we all respect him for that. Let me just say, I know you have participated in more than 1,000 cases, or decisions, rather, with Judge Alito. All of you, of course, can offer your thoughts as well. Yesterday, during the hearing, one of my Democratic colleagues held up some charts listing quotes from a few cases in which Judge Alito's colleagues criticized how he applied circuit precedent. The picture that was painted was that Judge Alito misapplies precedent when it suits him, suggesting, I suppose, that he might be activist or careless in this regard on the Supreme Court. Now, I certainly agree that the views of his fellow judges are particularly relevant on this point, and having you here is very valuable to all of us for that reason. Now, asking you all about this here seems more useful than a few selective sentence fragments on a chart. Now, realizing, Judge Becker, that judges do not always agree on every single point every single time, how would you characterize Judge Alito's overall view to or approach to precedent?
Respectful of it. I've never seen what was portrayed where Judge Alito might have disagreed with prior precedent. He followed it unless he felt that it was dicta, well, in which case it wouldn't be precedent,
right,
or the case was distinguishable. But I have never seen him ignore or disregard precedent.
Has any of the rest of you seen that?
No.
Judge Alderson?
Judge Hatch, Senator Hatch, please. I wanted to answer Judge Feinstein the same way. In my book, The Judicial Process, Text, Materials, and Cases, second edition, 1996, I have an entire chapter on precedent. And one of those sections is called viability of precedent, or when do you depart? And there's a sophisticated body of law, and I cite cases with Justice Sandra Day O'Connor, Thurgood Marshall, and a few others, and there are also some very important scholarly academic articles on it. And I think that Judge Alito's expression that it depends is a statement that you have to consider all the factors on all the Supreme Court cases that discuss when do we depart from precedent. And there's a body of law, and it's in my case book.
Thank you so much, Mr. Chairman. I want to thank all of these great judges for being here, and I want to thank you, Judge Lewis, for taking time to be here in particular. And we just really respect you. I love and respect the Third Circuit Court of Appeals.
Thank you, Senator Hatch. Senator Leahy.
Well, Mr. Chairman, I realize we have some retired and very distinguished retired judges, but some current judges. Insofar as the current judges, their cases are appealed to the Supreme Court. If Judge Alito becomes a member of the Supreme Court, he'll have to rule on their appeals from their decisions. And so I think rather than create a difficulty for them or for Judge Alito if he is confirmed, I think I will not avail myself of a chance to ask questions of this unprecedented panel.
Thank you very much, Senator Leahy. Senator Kyle.
Thank you, Mr. Chairman. I just had a question, and I think, Judge Lewis, it was a comment that you made that raised this question in my mind. There was a point made about the circulation of opinions among all of the judges on the court. When a three-judge panel has tentatively made a decision in a case and and circulates an opinion. Is that opinion circulated among all the judges, and then do all of the judges have an opportunity to comment on that in some way?
Yes.
And any of you?
Yes,
Judge Lewis?
that is correct, and that is why the opinion is the opinion of the entire court in the end when it is released. I should let Chief Judge Sirica address the current practice. I've been off the court for some time, but I assume it's done the same way. Is it not, sir?
This is interesting to me because I practiced before the Ninth Circuit Court of Appeals, and that same opportunity, I think, is not as available.
Yes.
Senator, that
was
is
invented by Judge Biggs in the late 1930s.
In which in the Third Circuit, sir?
Circuit.
we circulate all of our precedential opinions to the entire court before they are ever published, that is, before the litigants or before the public sees them. We do not do that with a category that we call not precedential opinions. They are handled by the panel themselves.
Dissent or a
Unless there is a dissent, in which case we circulate them as well. Now, of course, when a litigant loses a case, that litigant has the opportunity to file a petition for rehearing, and that goes to the entire court, because the litigant usually asks for both for panel rehearing before the original panel and also before the entire court. And so for precedential opinions, it gets sent to the court on two different occasions, one before it is ever published and one after it is published.
I'm curious, what happens if there's a strong opinion by one of the judges on the court who did not sit on the original three-judge panel? Who
that's
differ from the conclusion.
Any judge on our court, on the initial circulation or even on the circulation for the petition for rehearing, may write to the entire court or may write to the opinion writer or may write to the panel expressing his or her disagreement. It's one of the wonderful things about an appellate court because we view the panel decisions that are precedential as opinions of the court more than just the opinion of the panel or the opinion of the author of the case. And there's often this wonderful dialogue that goes back and forth between the opinion writer or the panel and a judge who may have concerns about what is being decided. And sometimes it can go on for days. Sometimes the panel will, or the author will say, I want to think about this. I want to have the opportunity to revisit this issue. And sometimes it takes weeks before the panel comes back with a new opinion, often a revised opinion. This is part of the collegial aspect of the court.
This should be very reassuring to the litigants.
And sometimes we'll go en banc before the opinion ever issues.
Yes. But often the panel will change its mind, say we got it wrong.
Well, it's very interesting, and I appreciated the opportunity to at least mention that. And I, too, want to thank all of you for your willingness to be here, to take time out, but most especially to speak on behalf of a colleague who I know you all admire a great deal, and I thank you for that very much.
Thank you, Senator Kyle. Senator Durbin.
Mr. Chairman, I thank the members of the panel for their public service. I have no questions, and I would like to associate myself with the remarks of Senator Leahy.
Thank you very much, Senator Durbin. Senator DeWine.
I have no questions, Mr.
Senator
Chairman.
Sessions.
I would just like to ask the panel, I see one of the articles that stirred up some of this discussion about not being even-handed, not being an even-handed judge, actually only considered 221 cases in the judge's first 6 years on the bench. I would just, I'm sure you, as professionals who've been there, your judgment is better about his style and fairness than some abstract numbers would be. But I would just ask you, Judge Sirica, maybe, and if others would like to comment, please do so. One, on civil rights cases that I've seen here, of the civil rights cases Judge Alito wrote, the panel agreed with him 90% of the time, and his opinions were unanimous 90% of the time. That doesn't sound like an extreme position to me. What would you say about that?
Well, I would agree, and that would comport with my recollection of these cases.
And I noticed the respect Judge Lewis had for Judge Alito. It said when he sat on panels where both the other judges were Democratic appointees, the decision was unanimous in 100% of the cases, or whatever those statistics show. And then with regard to the immigration cases, it says that his appeals, the average judge in the country, in the average cases, the immigrant wins asylum claims in the Court of Appeals in slightly over 11% of the time. But in Judge Alito's record, he ruled for the immigrant seeking asylum in fully 18% of the cases. Does those numbers, Judge Sirica, strike you as sort of what the, well, in the 11%, is that about what you would expect?
Yes, sir.
And with in the cases that he wrote opinions on, the average Court of Appeals judge ruled for the immigrants 8%. He ruled for the immigrants 19%. Well, I don't know that those numbers mean a whole lot, but I do think they tend to rebut some of the numbers that we've seen floating around, because it doesn't. His opinion, your opinion of him does not reflect a person who shows bias. No. In the Rybar case, Judge Gibbons, you're no longer on the bench. You could be honest with us right here in Congress. If the Congress had put in an interstate commerce nexus in the statute they passed about machine guns, like they did in ITSMV, interstate transportation of stolen motor vehicles, or interstate transportation of stolen property, kidnapping, or theft from interstate shipment, it would have been upheld, wouldn't it?
That's what he said in his dissenting opinion.
So the truth is that Congress missed the boat.
Yes. Just as it did with respect to recent unfortunate
and we could
legislation.
fix it as soon as we passed the law correctly, I would submit. And I would just ask this, Judge Alderson. I'm serious about this question, but I think Judge Roberts agreed with me that if an individual within the heart of Pennsylvania or New Jersey picks up a rock and kills another person, that is not a federal crime. Is that correct? Unless there's some added, without an interstate nexus of some kind, or that would be prosecutable solely by the state court.
Unless he stole the rock out of an interstate shipment.
So it could be a violation of federal civil rights also.
Killed, or the person that he assaulted was a federal official.
Right.
The president, or the vice president, or a senator.
That's great.
Well, Judge Lewis said it could be a civil rights violation. Correct. If it was in a way to deny someone of civil rights.
That's correct.
Or if it was a federal official. But classically, the federal criminal law has been tied to interstate commerce nexus, hasn't it, Judge Alderson?
Civil rights.
Judge Lewis.
That's right.
Thank you, Mr.
Thank you, Senator Sessions. Senator Cornyn.
Thank you, Mr. Chairman. I feel like I need to say, may it please the court. Thank you all for being here. It's very important, I believe, to have testimony from people that know this nominee. We've heard a lot of wild and crazy, from my perspective, accusations that have been unsubstantiated from people who don't know this nominee as well as you do. I want to just try to eliminate one concern that's been expressed, and I've heard a hint of criticism about these judges appearing as witnesses in this hearing, supposing that perhaps there'll be some conflict of interest if your decisions would be appealed to the United States Supreme Court and Justice Alito had to sit on it. I haven't noticed any lack of willingness to disagree with him while you were colleagues on the Third Circuit. That seems highly unlikely. And for the suggestion that this is somehow unprecedented to have judges, former and current sitting judges testify, Mr. Chairman, I have a list of examples where sitting members of the federal judiciary have testified during the confirmation proceedings of another federal judge, and I'd ask that that be made a part of the record.
Without objection, it will be made a part of the record.
Canon 4B of the Code of Conduct for U.S. judges provides a judge may appear at a public hearing before a legislative body, there's some ellipses there, on matters concerning the law, the legal system, and the administration of justice to the extent it would generally be perceived that a judge's judicial experience provides special expertise in the area. And I regret, Your Honors, that you somehow get sucked into the contentiousness and some of the unfairness that occurs sometimes, the innuendo that sometimes arises when you're a witness in a contested proceeding. As you can tell, these hearings have become, and the confirmation process, an adversarial process. The unfortunate part, as our chairman has noted before, it's not controlled by the rules of evidence, where it could be based on speculation, hearsay, and rumor, whereas we know in a court of law that wouldn't be admissible. And our procedures are a lot more flexible and open-ended, and certainly there's no standard of review that applies to judges in your distinguished and exalted position as members of the federal judiciary. Judge Alito, sir, I want to say that I guess I'm the only other panel member of this committee who's probably read one of your books, but I'm certainly familiar with your great work and your writings. And of course, has already been noticed, Judge Becker is very familiar to the Judiciary Committee. And I want to ask both Judge Gibbons, who's no longer on the bench, and Judge Becker, both of you who have talked about the transforming experience of crossing over from being an ordinary lawyer, or including a U.S. attorney, and then putting on the black robe after you put your hand on the Bible and taken an oath to uphold the laws and Constitution of the United States, so help me God. And what a different perspective that provides, a different obligation, different responsibilities. And I think Judge Trump-Berry noticed that transformation in this nominee when he crossed over from being a practicing lawyer to becoming a member of the judiciary. And Judge Becker, I wonder if you just might comment. We just have a couple of seconds here, but this morning Senator Biden was asking questions about this nominee's views on Roe versus Wade, and perhaps is reflected in an application he made for a job in 1985. And it seemed to raise the question of, well, if that's your view today, wouldn't you just feel free to go in and vote to overrule it? And it struck me because of the difference in a judge's role from that of an advocate. He was applying for a job as part of the Reagan administration. But on one hand, he was talking about, well, maybe you have the power, but what Judge Alito seemed to talk about most was legitimacy of the judicial making process and the judgments rendered by courts, and why that's such an integral part of the role judges play in our system of government. Would you please respond to that?
I agree with Judge Alito, and I think, Senator Cornyn, that you have eloquently described the transforming experience. I know that it is within your life's experience when you took the oath of office to be a justice of the Texas Supreme Court. It just transforms you. You become a different person, and your obligation is to the rule of law. And you have no interest in a case, and if I could just segue this into your original point, which bears upon what Senator Leahy had to say in terms of whether or not a justice of the Supreme Court would have to recuse on an opinion I wrote or one of our cases. I have no interest in the case. Recusal is a function of whether or not the party or the lawyer has an interest in the case. But I don't have any interest in any case. And Judge Reagan, none of us have any interest in any case. And this is consistent with what Judge Alito said and your description of that transforming experience.
Mr. Chairman, I would just say Judge Gibbons and Judge Lewis are no longer members of the bench. I'm sure have experienced the liberating transformation once you cross back over that Rubicon, perhaps, as well. Thank you very much.
Thank you very much, Senator Cornyn. Senator Coburn?
Thank you very much, and I appreciate so much you all taking the time to come here. As a physician, I'm starting to learn some of the lingo of the legal profession. It's hard. I'm going to start talking in doctor's terms so the rest of them can't understand. But Judge Berry, I wanted to ask you, and also Judge Lewis, do you think that there is any merit whatsoever to the allegations that were made that Judge Alito was hostile to the rights of women or minorities? And have you seen that in the 30 years? Have you seen any indication whatsoever, either in his opinions, his personal life, his interpersonal relations with you, or you, Judge Lewis, that there's any indication that there's that type of bias in this man?
I have never seen it, and if I had seen it, I would not be here today.
Judge Lewis?
I've already said that if I sense that Sam Alito, during the time that I served with him or since then, was hostile to civil rights or would be hostile to civil rights as a justice of the United States Supreme Court, I absolutely would not be here today. I am not interested in saying anything on behalf of someone that I believe would hold views like that or would proceed in that way. I am basing what I am saying on my years of experience in conference with him, discussing cases, and we have different views and different approaches, but never would I suggest did it seem to me that he was held any hostility to civil rights, which is an area that I hold very dear and is very important to me and remain committed to furthering in this country.
Thank you. Well, Mr. Chairman, I don't think you can have a better recommendation than the people that you work with, and the people that you spend the greatest amount of time with, and the people who see you under stress, who make evaluations. And the greatest tragedy, I think, of this hearing is the allegations that have been made that aren't substantiated based on fact, but are substantiated on the basis of the fact that you want to try to destroy somebody's character and undermine their character to make them look in a certain way in which they're not. And I appreciate your all's very straightforward answer, and I think you come in and I yield back my time.
Thank you very much, Senator Coburn. The question has been raised as to precedents, and Senator Cornyn has addressed that. And it's worth mentioning just a few that former Chief Justice Berger testified for Judge Bork. District Judge Craig testified for Chief Justice Rehnquist. District Judge Tanner testified for Justice Thomas. The canons, specifically 4B of the conduct of U.S. judges, makes a specific allowance for this kind of a situation. Quote, a judicial experience provides special expertise to the area, and it is certainly obvious that the insights which you judges have to Judge Alito's background is unique. When you talk about what goes on in those conferences, you're the only ones who are there, and you have much more insights as to the opinions he has written that you have worked with him on. We have 30 witnesses who are coming in, and that has been a traditional part of the process. But I know of no situation where witnesses have more to say which is relevant and weighty. Perhaps weight is the best evidentiary characterization of what you've had to say. A lot of things can be relevant, but especially where you have the issue which has been before this committee as to Judge Alito's agenda or Judge Alito's approach or Judge Alito's personal views dominating his judicial determinations. This panel is right on the head, and it has been an unusual panel, but that's really not a strike against the practice. It may be a precedence for the future, and it, I think, will be a good precedent. But whenever you try something new, there are differing voices. But I think it's an extraordinary contribution which this panel has made to this process. So Judge Becker, former Chief Judge Becker, Chief Judge Sirica, Judge Berry, Judge Aldiser, Judge Gibbons, Judge Lewis, Judge Garth from Phoenix, Arizona, you lucky fella. We thank you all very much for coming in. We're going to take only a 10-minute break now. I didn't have a chance to discuss it with Senator Leahy, but we do not have the situation where Judge Alito is on the stand and he needs a little longer break. We'll have fresh witnesses and tired senators. 10 minutes, we'll resume at 5:20.
Wonderful.
And you heard Senator Specter mention a 10-minute break now in this day 4 of the confirmation hearings for Judge Samuel Alito. You heard Senator Specter kind of wrapping up this last panel of judges, a bit of a discussion earlier today about whether some of these, whether Judge Alito should step aside if cases come before the court involving some of the judges who testified today. And a bit earlier, Senator Feingold spoke about that subject.
As you know,